Mr. Parks, when did you discover that these charges that are pending currently against you personally developed? When did you find out about that?
This past Monday,
And how did you find that out?
by going to the city website where the agenda for today's meeting was posted.
And why did you happen to look at the website on that particular day?
From time to time, I look at the website because tenants of Norino Properties do hold liquor licenses, are involved in the bar business, and I look on there to see what might be affecting any of the tenants.
Okay, and effectively, these tenants have pledged their liquor licenses as security for loans and for rent. Is that correct?
That's correct.
Okay, so that was the purpose of your checking into this. And before Monday, did you have any knowledge, first of all, that this license had not been transferred to the name of Mr. Willibus on July 27th?
I had no knowledge that the transfer was not completed.
Do you have any reason to suspect that the license had not been transferred?
No, because I was told the license had been transferred
Okay.
by Mr. Willibus.
Now, this license was actually in your name actually, it's currently in your name, although you didn't realize that. And you held this license for how long?
Not long, 2 to 3 months, I believe. I purchased it at auction.
Okay. But you did operate the business, is that correct?
That is correct.
Okay. And the business that was operating is called 532?
532 North Monmouth.
Okay. And that's a corporation that you formed when you operated another establishment, is that correct?
That's correct.
And that was also in Baltimore City, and it happened to be at 532 North Montfort, is that correct?
That's correct.
Okay, now, so you've had the license in this city for, in 2 different establishments, is that correct?
Correct.
Did you ever have any violations whatsoever
No.
during any of that time? Okay. If the board were to revoke this license based upon these actions by Mr. Willibus, how will that affect the security for the loans that were given to him?
There would be no security.
And would the secured creditor suffer irreparable harm?
Yes.
Okay. I have no further questions.
I've got quite a few questions for you, Mr. Parks. I'll take it in reverse order. You indicated that you operated this business for some period of time.
In trying to bring the building back into a situation where I could actually open up as a tavern.
So you were serving customers?
At that point, yes, once a day for a short period of time.
All right. No, I only remarked that because it looks like you had a transfer conference over at the agency on late February, maybe
Right.
February 26th of this year, and then you testified that you tossed the keys to Mr. Willibus end of March, so that it would only leave you.
About a month and a half. I think I said about 2 months.
Okay. What is your role? What is your position with Norino Properties?
I'm an accountant.
Okay, that's your title?
Yes.
Okay, you're not on the board?
No.
Okay. Obviously, Norino Properties is no stranger to the rules and regulations of the Liquor Board.
Yes.
Isn't that right?
That's correct.
They also know who to call at the Liquor Board if they had a question, right?
That's correct.
So they're obviously not rookies, first time doing this in business.
Norino Properties is not.
Right, right. So you were notified when you were violated by this board. You were charged by this board for something that Mr. Willibus had done. Isn't that right?
I don't recall.
All right, on or about July 19th, 2002, the board, under your name as licensee, found the licensee guilty of 2 charges and assessed a fine of $1,125. Is this the first you've heard of this?
Yes.
All right, so at that time, I mean, I don't, if I could get a staff member to see if there was service on the licensee at that time. That's what we're really having a hard time dealing with here, is that we have our records, and in fact, our transcripts show there was a hearing with your name on it, right before the transfer conference. Were you not present for the transfer conference of July 19th of this year? So there was, so you're telling me you were never, you received the license back in February of 26th of this year. The transfer conference between you and Mr. Willibus was held on July 19th of this year, isn't that
I
right?
don't remember. I mean, I don't remember going to a conference.
The seller doesn't often
I
appear.
understand that, but the seller might check to see that it was done.
Oh,
And the
okay.
seller might there find out that there were violations in the seller's name on July 19th of this year. So, Mr. Parks, so you're telling me that even though you were selling the business on July 19th, and even though you sometimes check the website, that you never found out that your name was up for violation,
That's correct.
or that you were assessed a fine?
That's correct.
On the same date as that transfer conference, that you would have wanted to check in on and find out how that might have gone?
I check infrequently. It's just a random,
All right, I mean, the problem is you testified, you turned the keys over to him end of March. But then there's a May violation, May 4th violation that results in a July 19th violation hearing, at which time you, sir, were found guilty of a wholesaler violation and of illegal cigarettes. It was a comptroller case. I mean, I have the transcript for you right now. While, yeah, you may never have testified, we're looking now and we see notice dated July 5th, and the notice is normally taken to the bar. And in fact, Mr. Willibus signed for, now this says 5th of July by Agent Mark Fosler. So, but again, it's your testimony, you have no idea what happened on May 4th or on July 19th for that matter, when these matters were docketed before the board for public hearings.
that's correct.
Okay.
What are you thinking about that? Did you renew your license for 2012?
Yes. I mean, you're
Okay.
catching, I apologize, you're catching me a little off guard because,
When you thought the sale of the property went through, did you go and retrieve your license from the establishment? What did you do with your license? Where's your license now?
well, the license was in my possession. We had the license, as I recall, I mean, it was given to Mr. Willibus along with this documentation, take it in, turn it in.
You trust that Mr. Willibus to turn your license in? That's what you're saying to me?
Yes.
The secured creditor is you, Mr. Parks, or it's Norino Properties?
The Reno property.
Okay. All right. I don't have any further questions. Commissioners?
I just have a couple
Certainly.
more for Mr. Parks. Is this the first time that you've heard of this May 4th violation?
Yes.
As a matter of fact, didn't you testify earlier that you didn't authorize Mr. Willibus to operate this establishment until the license was actually in his name?
Yes.
And were you personally notified of a hearing?
No.
And I'm curious, do your records indicate whether or not the licensee actually appeared at the hearing?
Our records do not indicate that he testified. I mean, whether or not he was here, as sometimes applicants or sellers are at a transfer conference, that wouldn't be in our records. But he did not testify, and that's the record that we have.
And then, so the transfer conference that took place on July 19th was a little more than a week prior to your actually signing the transfer authorization form from Mr. Wilbus, is that correct?
That's correct.
And the affidavit of compliance from Mr. Wilbus, is that correct?
That's correct.
And you were holding those documents until it was time for transfer, is that correct?
That's correct.
And so that was the purpose that you gave him those documents on July 27th?
Yes.
Correct? Okay. All right, no further questions.
Just one follow-up. Did you ever visit the premises since you gave the keys over to Mr. Willoughby?
No.
All right, anything else?
No.
All right, at this time, we're going to ask Mr. Avila if he has anything he'd like to offer regarding ownership for these events.
Okay.
All right, thank you very much. Mr. Carlos Avila, that's A-V-I-L-A.
Yes.
All right, sir, do you have anything that you would like to add regarding the transfer of ownership or the violations that have been charged?
No, just one thing about the the shooting. They say was inside of the building. So the detective they say that was from inside. Somebody from inside.
You say the shooting was outside the building? Is there anything else you want to say?
No,
Mr. Avila, when's the last time that you've communicated with Mr. Parks?
Mr. Parks.
Yes.
No, I never seen him before.
You've never seen him before.
This is the first time I met him.
You're authorized to speak on behalf of Mr. Willibus?
Yes.
Did Mr. Willibus communicate any timeline or any activity or communication with Mr. Parks to you?
No.
Okay, thank you.
Well, I have some questions for him.
You may.
Certainly may.
Mr. Avila, how are you connected with this Crossroads Station LLC?
I work for this company for like 4 years. You know, they
Okay.
got different kind of business and maintenance.
Okay, so who's the principal of Crossroads Station LLC?
Well, Antonio Willabas.
Okay. Now, did you at any time work at this particular location, 291 South Pulaski Street?
Do kind of maintenance in there and try to make sure everything is okay now.
And you work for Crossroads Station LLC, is that correct?
Work for cross station sometimes, and like I say, do maintenance and make sure everything is right there.
Well, do you work,
They have another properties I'm do maintenance for.
but your employer is Antonio Welbus or his LLC, is that correct?
Yes.
Now, you said you visited 291 South Pulaski Street?
Yeah, what? Sorry.
Have you been to 291 South Pulaski Street?
Yes.
When was the last time you were there?
There was like this Saturday or Friday. It was Friday.
Recently, just this past Friday?
Mm-hmm.
And how often did you go to this location?
Like 3 times a week, something like that.
Okay. Now, what is your understanding of the ownership of this business? Who owns the Who owns the business?
I'm not, like I say, I'm working for the company who is management this place because they had another properties. That's what I do, maintenance for them.
Okay, but do you have knowledge of who owns Crossroads Station? The business?
The business?
Yes.
Like another property, the business.
Yeah, the business. Who owns the business?
But the business now is Antonio Willabas. That's what I'm working for.
Okay.
But the property is on Orino's properties.
The business property, but the actual business, the tavern business, is owned by whom?
That's because I'm working
No,
for.
who owns the tavern business?
Like I said, I'm working for him, and that's what I'm working for him is that he's on the place. Not on. He
Who's he?
Antonio Willabas.
Antonio Willibus, okay. And you've never met Mr. Parks before, is that correct? All right, no further questions.
All right, I think, are there any other questions that commissioners have of any of the witnesses here?
None.
Anything, Mr.
I
Harvey?
just have a question about the actual file.
You may ask.
Okay, well, maybe I should wait. I don't know.
All right. Is there anything else before we go off the record?
Yes. Thank you. I believe is in front of you, is that the transfer file?
I believe it is. We'll give you a moment to review it.
Yeah.
Off the record, if you like.
Thank you.
Yes.
Off the record. And you're welcome to sit down if you'd like.
Do you have any use for the cadet?
No, he's released. Thank you very much. The cadet is free to go, right?
Well,
I mean, are you arguing from the grounds of standing and ownership, or are we?
Well, I just wanted to put into the record that there is a food permit license here that's in the name of Crossroads.
All I asked you was, can the cadet go?
Oh,
Yeah. Can he go?
yes.
Okay, cool. No, we'll come back on the record, and you're still able to put
Okay.
more evidence on.
Thank you.
We're just taking a break. All right, folks, we're going to go back on the record. And Mr. Harvey, I understand you have some documentary evidence for us at this time? All right, we're on the record. Mr. Harvey, you have some a document for us?
Yes, well, actually, this was as part of the Liquor Board's official file for change of ownership, the license, and I found among that a copy of a Baltimore City Health Department food permit dated April 19th, 2012.
All right, from our file, it's a food permit in the name of Crossroads Station LLC dated, as Mr. Harvey said, April 19th, 2012. Licensee's 10. Anything in
And
closing?
it was issued to Crossroads
Right.
Station LLC. Yes, and also, I'd like the board to take note also, I have the original application for transfer of the liquor license here in my hand, and also a copy that was also contained in your record. And the applicants were a Clyde Wilbus and a Carlos Avila, who apparently is this gentleman here. So he was actually an applicant for this
Right.
transfer. I'd like Mr. Parks to look this application over, if you don't mind. Okay, front page, back page. Now, down at the bottom, it says, if this application for a transfer from another licensee, please have that licensee sign below to indicate their consent to the transfer. Do you see your signature there at all?
No.
There is something that says, it looks like Parks, but is that your signature?
No.
Not now. Also, inside, there's, appears to be the signature from the landlord of these premises. Is that correct?
Yes,
And the landlord's title is Norino Properties, Inc., is that correct?
that's what the document says.
Does Norino Properties, Inc. own that property?
No, the property is owned by Norino Properties LLC.
And there's a signature here, do you recognize that signature at all?
No.
Okay, so the application was submitted and apparently not signed by my client with his testimony.
So how does that help your argument?
Well,
I thought he thought it was transferred, so now you're saying that he didn't
Well,
mean
that's-
for it to be transferred.
did you ever sign an application to transfer?
Yes.
Is that the application?
No.
Well, what it means, unfortunately, is that my client's been the victim of a scam artist, who my client, the record will show, this is information, I suppose, that my client entered into an agreement to sell this business to an LLC, which is controlled by an Antonio Willibus. And he testified and he signed an application to that effect. And the application which is before the board here is not the application.
I will note we'll take the copy and we'll introduce a copy of the application, the alcoholic beverage license application as the 11th exhibit.
Now,
Anything in closing?
yes, just in closing, I mean, first of all, I want you to understand, my client, Mr. Parks, understands the gravity of this situation. I mean, you know, this is a pretty respectable businessman who's had a license with this board for 2 different establishments, never had a problem, especially like this. I mean, you know, he testified, and the records will show that he entered into a legitimate purchase and sale agreement for this tavern to this guy named Antonio Willibus, who actually represented himself as an attorney. Parenthetically, I checked my lawyer's manual before I came here today, and his name doesn't appear in it. But he did represent himself as an attorney. He drew up the agreement of sale. The detective testified on a few occasions, on some of these occasions, I think on September 28th, October 18th, I believe also on September 16th, that he looked at the license and saw that it was issued to Crossroads Station.
Okay.
Yes,
Okay.
he testified, correct? Correct. And so the license, I don't, you know, I didn't have any reason to suspect that the license may have been altered, but if that's the case, then it may have been altered as well. And I don't know why they didn't take Mr. Parks' name off of it, but the bottom line is Mr. Parks entered into this legitimate business arrangement to sell this business to Mr. Willibus's company, He did not authorize, according to the testimony, Mr. Willibus to operate this establishment until the license was actually transferred. He didn't give the actual authority to transfer until almost 4 months, actually 4 months after the agreement was entered into. Bottom line is, my client is, I believe, completely, except for the legal implications of being the actual licensee, he did not understand himself to be the licensee during these incidents, was not made aware of them because all the notices that are sent to the establishment. I'm just hopeful that the board will consider Mr. Parks's culpability in this matter, and also the tremendous financial burden it would be if this license were to be revoked under these circumstances. I don't know that there may be some criminal fraud going on here, but I don't think that it has anything to do with Mr. Parks. Mr. Parks may not have had his eyes as open as they should have been. I've been doing this sort of law for over 25 years, and I was involved with plenty of transfers of licenses, and we go to settlement, and you give them the license, and I don't ever remember ever going to the liquor board and making sure that the license was actually transferred. Usually, the purchaser is anxious to get that license in their name. It's a property right that they want to have.
And usually, people pay $20,000, $40,000, $60,000 for those licenses up front, which sort of minimizes the problems that we have here when you sell licenses for $5,000 down and $1,000 a month.
Right.
Basically letting anyone in the world be a liquor licensee.
Well, again, the gentleman.
But who you contract with matters,
Yes.
Mr. Harvey.
Well, I understand that.
Is there anything else?
No.
Okay. We'll go off the record. All right, we'll go on the record. 3 p.m. decision phase. James M. Parks, 532 North Montfort, Incorporated. Licensee applicants Clyde Willibus and Carlos Avila. Crossroads LLC trading as Crossroads Station, 291 South Pulaski Street. A panoply of violations here today, serious in violations. First, we have to determine who the licensee is, and as will not surprise anyone, the docket calls Mr. Parks a licensee, and we have to agree that Mr. Parks, in fact, was the licensee and still is the licensee as of this very moment. And what has happened here is that apparently the applicants must have failed to deliver 1 or 2 documents that would have completely finished the transfer. And while Mr. Parks did an excellent job of protecting himself so that he'll have a judgment and hopefully get paid by Mr. Willibus, going out of his way to make sure that Mr. Willibus signed both individually and on behalf of his LLC, making sure that it's an ironclad commercial lease with his employer. And in every other way, Mr. Parks did his due diligence in this project, except for the very basic finishing touch to this project. Now, I have to wonder if there was a licensee who wanted to sell and it was their only license and it was their life savings, would this have gone differently than if you are managing lots of properties and lots of licenses and you're a very busy person? Something slipped through the cracks here, but it's almost inconceivable to us that a murder occurred in this in this establishment over the summer, and Mr. Parks was completely unaware of it, even though we had a violation hearing with his name on it that was scheduled for the same day as the transfer conference. I mean, we're trying to give you the benefit of the doubt. We're not saying that you're being dishonest here, but somewhere the ball was dropped, we believe, in that you didn't just inquire with the liquor board to double and triple check that, in fact, this license had completed its transfer. It didn't happen. And the problem is we have very serious charges that we have to deal with some licensee. And it's this old, this is a situation where customers and people who deal with the liquor board, it's well known that the licensee is in charge until he's relieved of the licensee, until he no longer is the licensee. And you must have known that when you turn the keys over to Mr. Willibus, prior to the transfer even being considered by the board, you testified you turned the keys over to Mr. Willibus in late March of 2012. The liquor board didn't even have a public hearing on the transfer until July the 19th. So you must have known that anything that happened in that bar that Mr. Willibus may or may not have done between March 30th and July 19th was going to be your responsibility, because that is the case. So after July 19th in the public hearing, again, we don't want to ascribe fault here, but we feel that we have to determine, we have to uncover the facts here and determine who is the licensee. And what we see is that, in fact, you are still the licensee because the transfer was never completed and deemed completed by our agency. That having been said, the charges were denied. The charges, and we've obviously spent more time talking about title than we have about the violations that are alleged to have occurred and the murder of a customer and the real victim in this entire chain of events. So in that regard, we heard from Donald Fitzgerald, our liquor board agent, who indicated unauthorized use of the second floor premises on or about September 16, 2012, when he responded at the request of the Baltimore Police Department regarding a shooting that he indicated through observation that did in fact occur inside the premises. Mr. or Agent Fitzgerald determined that there were underage patrons. These are underage patrons in the club at the time of the shooting, that there were at least 190 people in a bar that is what he testified to as having a capacity of 35 persons. We, based on Officer Fitzgerald's testimony, did determine that there was a violation on the evening of September 26th of Article 3.1, Rule 3.12, indicating that the licensee failed to avoid disturbing the safety and peace of the neighborhood. Can I have, we're going to go off the record. I just need to have thank you very much. That's the expanded version. All right, so based on Agent Fitzgerald's testimony, we do determine that when he responded to the overcrowded club on the night of September 16th, where an underage patron was shot and killed, that indeed the licensees failed to avoid disturbing the peace, safety, health, quiet, and welfare of the community. We further determined, based on the officer's testimony, well, in this case, actually Agent Fitzgerald's testimony, and a police report by Officer Officer Tudhill, dated September 16th, that persons under the age of 21 were indeed consuming or possessing alcoholic beverages under Article 2B 12108D. The board, based on Agent Fitzgerald's testimony, cannot determine whether or not sales were made to both the decedent and to other individuals based on the evidence before us. So it's not guilty as to the 4.01A charges of September 16th. Next set of charges moves to September 28th, when Detective Greenhill visited the bar at 291 South Pulaski Street, 12 days after a murder had occurred at the bar. He went upstairs and determined that the second floor was still in use, even though Agent Fitzgerald had made it very clear to the applicant at that location that the use of the second floor was not to be permitted. Detective Greenhill noted that the health department had determined there were health violations at that time, including mice and flies, and a lack of general cleanliness and bathroom products. Agent Fitzgerald also noted illegal live entertainment. I'm going to go back to September 16th. And that in and of itself is a violation of Article 2B, 10202E21, for which the licensee is found guilty. So, Detective Greenhill, we really haven't had any challenging of the testimony of the events that occurred beyond what names were on traders' licenses, certificates of occupancy, health permits, and food permits. And I understand the position that Mr. Parks is in, that he may not be able to challenge the factual basis because he was never there, because he didn't think he owned the bar anymore. And it's a very difficult position. We understand that you're in here, sir. And there certainly was some miscommunication, but let me go on. So we do find on September 28th that there was a further violation of Article 2B, 10202E21, when Detective Greenhill observed the use of the second floor and the use of a DJ playing music of the second floor pursuant to his report. So we find the licensee guilty by preponderance of the evidence. So on October 18th, the use of the second floor and the live entertainment also constitute a violation of Rule 4.18, commission of contrary to law on the premises, and he will find the licensee guilty of September 16th and September 28th in that regard. And it is shocking that 12 days after there's a murder, that it's business as usual, even illegal business as usual in this establishment. So it's clear to us, based on Agent Fitzgerald's initial report, that the capacity, whether it says 55 in our charging document here, agent testified to 35. He estimated 190 people in the establishment, so it really doesn't matter if it's 35 or 55. It's not even close. It's either it's 350% capacity or it's 500% capacity. Either way, it's grossly and dangerously over capacity. As far as September 28th, when Detective Greenhill visited the establishment, he noted the violation of the health department rules and by a preponderance of the evidence. That's also a violation of 3.06 rule. Agent Fitzgerald testified that no employee records were made available the night of the shooting, September 16th. And that is a violation of Rule 303C. By the testimony of Agent Fitzgerald, we do find by a preponderance of the evidence that that rule was violated, and the licensee is guilty thereof. We'll move on to October 18th, when, not surprisingly, Vice, the Underage Drinking Task Force, decided to see if we could buy some liquor from there, from a cadet, Cadet Hightower, who someone said doesn't look like he's 28 years old. He actually looks a little bit young. And in fact, pursuant to Detective Greenhill's report and evidence and Detective Greenhill's verbal testimony, indeed, Cadet Hightower did purchase a half pint of gin. And at that time, Detective Greenhill happened to notice that once again, the second floor was in use without permission from the liquor board. He, at that time, mentioned to the manager that this use was not permitted. At that time, he also saw crabs being served and heated by portable heaters, which he knew was a violation of the health department rules and regulations. So yes, on October 18th, 2012, we determined by a preponderance that there's a violation of Rule 4.101A, selling or furnishing to a person under 21 years of age. We further determined, based on Detective Greenhill's testimony and report of October 18th, once again, under Article 2B 10202E21, that the patrons were using the upstairs without permission from the liquor board. Also on October 18th, a 3.06 rule violation was established in that the licensee was not operating the establishment in accordance with the requirements of the Health Department of Baltimore City by serving steamed crabs with portable heaters without the appropriate food permit. Additionally, on October 18th, 2012, we determined that the board formally warned the establishment on September 16th, the night of the shooting, not to use the second floor. But on September 28th, when Detective Greenhill visited, it was used. On October 18th, when Detective Greenhill and Cadet Hightower visited, it was in use. And as we're about to get into, it was used on November 3rd, when Detective Greenhill appeared yet again at the bar. 3 times in a row after September 16th. So basically, in 6 weeks, this was continuously going on. I believe Mr. Willibus told Detective Greenhill at the November 3rd event that there was a private party, as if that mattered, and it appeared to put some kind of a lock on it as to suggest that he wouldn't be using it at least for the rest of the night. That's a patent violation of non-cooperation and playing cat and mouse games with the board and police and our agents. And getting to November 3rd, detective's report of that day, wherein he indeed saw the second floor being used, adult entertainment, some kind of live entertainment going on. And the live entertainment, adult entertainment, was actually testified to by Agent Fitzgerald back on September 16th. In this case, on November 3rd, and October 18th, and September 28th, and September 16th, it's a 4.18 rule violation. I don't know if there's anything that I've left out, any charges we have forgotten to deal with here. Perhaps the November 3rd incident, another violation of Article 2B 10202E21. The second floor once again being used without permission from the board. Evidence to suggest that, in fact, it was in continuous use with empty beer bottles and plastic cups with alcoholic beverages. So, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 guilty findings. not guilty to the 4.01A, 2 counts allegedly occurring on September 16, 2012. It is regrettable that this situation occurred, the murder occurred on September 16th. It's clear to us that there was gross negligence in operating this bar with at 350% capacity, without any permission to be upstairs, without live entertainment, without adult entertainment. And someone has to be responsible for that. And very unfortunately, the board's determining that it is Mr. Parks who is responsible. We can't deal with traders' licenses. That's not our agency. We can't deal with health permits or food permits, and that's what we kept hearing about. Is well, whose name is the food permit and whose name is the health permit in? But we can only deal with the liquor license, and the liquor license was in Mr. Parks' name at all times. You clearly have some kind of a claim against Mr. Williams. It's obvious that there was no administration or very poor administration in the bar while he was managing this bar under the management agreement, under the agreement that you had with him. So, you know, we're happy to hear from the secured creditor. We always are. But as of right now, I mean, the status of the license is obviously revoked due to this misconduct. You have 10 days to file a reconsideration with us. You are the secured creditor. You have 30 days to file a application for administrative review of our administrative decision with the Circuit Court for Baltimore City. I feel terrible that what appears to be Mr. Willoughby scammed you. But the board has determined legally that you're the name on the licensee, and that's how we proceed. So I hope there won't be any hard feelings, and we're off the record.
Appreciate it.
We're adjourned.